Today's video will address a question I get so often from clients. Should we put our assets in our children's names during our lifetime? There are generally four main reasons people cite for considering transferring assets to their children during their lifetime: tax savings, Medicaid eligibility, asset protection, and probate avoidance. Let's take each of these in turn. Tax savings. Explained in plain English. And a disclaimer, I am not an accountant, and I always recommend that clients consult with an accountant for specific tax strategies. This video is not intended to address tax issues associated with limited lifetime gifts. Rather, I'm talking about major gifts, such as your real estate or significant financial assets. That said, here's some general background information about tax matters. Regarding the estate tax, many people worry about estate tax, but for most middle-class families, there's no cause for concern. This is because the federal estate tax exemption is very large. Now, the state of Minnesota is one of the few states that also imposes an estate tax. As of 2026, the exemption amount is $3 million per person or $6 million for a married couple in Minnesota. This means that if the value of your assets is less than $3 million or $6 million for a married couple, your estate will not pay any estate tax. So, only people with multi-million-dollar estates will benefit from meaningful estate tax savings from lifetime gifting. For my clients who face an estate tax, we develop formalized gifting plans and revisit them regularly. But for the majority of us, estate tax avoidance is not a reason for lifetime gifting. Capital gains tax. This is a big one. If you give appreciated property, like stock or a house, to a child while you're alive, the child inherits your original price as their tax basis. That's called a carryover basis. If the child later sells that property, they pay capital gains tax on the full amount of appreciation from the date of your purchase. Contrast this with what happens if the child inherits the property after you pass away. In that case, the child will usually get a step up in basis. That is, the property will be valued as of the date of your death. Your child will then only be responsible for realized capital gains tax on the amount above the stepped up value if the property is sold. The capital gains tax, which would have been due from the decedent, will be completely eliminated, and that's a big deal. Medicaid eligibility. Many clients often think giving assets to their children will help them qualify for Medicaid benefits to pay for long-term care in a nursing home. Now, Medicaid planning is very complicated and subject to numerous changing regulations. If you have significant wealth and income sources, gifting is probably irrelevant. But if you're on the borderline, gifting may be a legitimate strategy to qualify for benefits. Very importantly, as of the date of this video in 2026, in Medicaid planning, the timing of gifting really matters. Medicaid has what's called a look-back period. If you gift assets within that look-back period and then apply for Medicaid, you can be penalized or delayed in eligibility. Now, there are alternatives that may be available to you, such as a properly structured irrevocable trust. These trusts and other elder law tools can provide for eligibility, protect assets, and preserve some control, but they must be set up correctly and early. If your goal or intent is Medicaid eligibility, my strong recommendation is that you consult with an attorney experienced in elder law before you transfer any property to your children. Asset protection. Some people think that transferring assets to their children will protect these assets from liability arising from lawsuits and other creditor claims. Gifting for this reason, however, can backfire. Once your assets are in your child's name, those assets are exposed to your child's creditors, divorce, or legal problems. If your child gets sued, your former assets can be taken. If your child has financial problems, debt, or risky behavior, you've effectively exposed your assets to those risks. In addition, if your child were to die before you, those assets will pass on to the child's heirs, not back to you or to your other children or your other intended beneficiaries. Again, other asset protection strategies, such as establishing an LLC, possibly, may be available to protect assets in your unique situation. Probate avoidance. People dislike probate because it can be slow and costly, but giving everything to your child to avoid probate is usually a subpar strategy. Again, you give up control, create tax and creditor exposure, and risk family conflict. There are better ways to avoid probate, such as trusts, effective beneficiary designations, and proper asset titling. Many of the problems discussed in this video are impossible to fix once the gift has been made. If your goal is asset protection, Medicaid eligibility, tax efficiency, or probate avoidance, consider these alternatives. A revocable living trust. This retains control, avoids probate, and provides extreme flexibility. An irrevocable trust. This can protect assets and allow Medicaid eligibility. Proper beneficiary designations for retirement accounts and life insurance, which will often pass outside of probate. If you're thinking about transferring assets to a child, pause and get advice. The consequences are often permanent. Know your goal, understand the risks, and choose a solution that protects both your assets and your family relationships. Thank you.